Aha, Mr. Bond. I've been expecting you. What am I talking about? I'm talking about spying. Sorry, Cappy, you can go up there for now. Yeah, this Chinese spying case that was dropped. I did a video a couple of videos ago about it, but just to give you a recap and save you having to sort of click on that. Two guys were prosecuted, were about to be prosecuted for spying for China under the Official Secrets Act. And the Official Secrets Act, as it was then, made it an offence to provide information to, quotes, an enemy, to an enemy state. So we got into the definition of what's an enemy state. It used to be, effectively, that it was somebody who either we were at war with or we were de facto at war with, like the Cold War, with like Russia and everything. But while the Chinese case was rumbling away in the background, there was another case where six, I can't remember if they're Bulgarians or Hungarians, something wombly anyway, they were also prosecuted for spying. And in that case, for spying for Russia, and in that case, the court decided and said, well, no, whether a state, a foreign state, is an enemy is just a matter of fact. It's just something for the jury to decide. It's just an element of the offence that the prosecution have to prove. So they can put in evidence as to why this country is an enemy, and the defence, if they wish, can put in evidence to rebut that, and then we leave it all to the jury. So effectively, it's widened the scope of the offence. Of course, the way the common law works, it's not changed the law, it's just interpreted the law and clarified the law. So now we all know. But yeah, arguably, it made it easier to prosecute because it just said you put in evidence as to whether an enemy, you don't have to show we're at war or anything like that. You just have to put in evidence and it's up to the jury to decide if that just meets the everyday common sense dictionary definition of enemy. This is all changed now anyway because there's new legislation that just makes it an offence to provide information to, quote, a foreign power. So that's a lot simpler. Although I can think ahead and think there might be some complications there because, well, if it's a friendly state and you just provide some information. But anyway, I'll maybe do another video on that on another time. So, the test seems easier. So all you got to do is do a prosecution, put in some evidence that the the state receiving the information was an enemy. But in this particular case, the CPS took the decision applying the test, and the test they have to use is a two-part test. Is there a realistic prospect of conviction, and is it in the public interest to prosecute? Well, obviously prosecuting spies, there's a public interest there, but was there a realistic prospect of conviction? And somebody in the CPS has said we came about 5% short, we didn't quite get there. Now, realistic prospects of conviction, it's not the same as is there a prima facie case. It's a prima facie case is just if this evidence was unchallenged, could a properly directed jury convict on this evidence? So you don't consider anything that the defence might say. Whereas when applying the reasonable prospect of conviction, you actually try and anticipate and say, well, hang on, could the defence say this? Could the defence say that? I mean, obviously, you're second guessing a little bit, but it's an ongoing thing. And in Crown Court trials now, you have to put a defence case statement in, where you effectively say, this is what our defence is going to be. And once you put that in, first of all, that triggers what we call secondary disclosure. I've done videos on that. But more importantly, it might be then you say, well, this is our defence, have another look at whether you've got a reasonable prospect of conviction. But in this case, they fell short. However, the government has now released 3 witness statements from somebody called Matthew Collins. And these statements were all provided to the CPS on the issue as to whether China was an enemy. So who's Matthew Collins? He's one of 3 Deputy National Security Advisors. And they work underneath the National Security Advisor, who is the person who liaises with the Cabinet, with the executive, on national security issues. So basically they get input from the various intelligence and security agencies, MI5, MI6, GCHQ, some of the other sort of spooky people out there. And he put in these 3 statements. Now they're very interesting because obviously he says, look, I'm a bit limited in what I do because I can't sort of reveal too much, operational security stuff or how we gather intelligence. But I have to say, and I'll link to the 3 statements in the description, because they're quite interesting and they do reveal quite a lot. I mean, basically, they just fall short of going, this is the name of the guy, the guy in the Chinese cabinet who's leaking all this information to us. But they looked at, what's going on, and just to give you some key highlights. He described China's intelligence services as highly capable, which I think most people would agree they are, and that they, quote, conduct large-scale espionage operations against the UK to advance the Chinese state's interests and harm the interests and security of the UK. Goes on. China's espionage operations threaten the UK's economic prosperity and resilience and the integrity of our democratic institutions. And he noted that, there was information that they tried to sort of hack the Electoral Commission. They've engaged in, quotes, online reconnaissance activity, which basically means hacking MPs' emails. So, that is the evidence of the harm. Now, nobody's saying you've got to take that definitively. We're saying that, that's something that the jury would have to consider. And it could be that if these statements went in, the defence could say we wish to cross-examine on this as to whether or not your conclusions are correct. I mean, that would be very interesting because you'd get into sort of national security issues there, and the court would have to go, quotes, in camera. So, there wouldn't be any reporting or anything like that. And you might even get what we call the special advocates procedure, where it's all sort of you've got these government vetted lawyers who can sort of discuss this. It all gets very complicated. But the fact of the matter is, these were the statements that, the government put in to the CPS. But for some reason, the CPS has said, we don't think these were enough. We don't think they crossed the threshold. And like I say, I'll leave it to you, because the interesting thing is, this would have just gone to a jury to decide. Now, in fairness to the CPS, they are supposed to apply that realistic prospects of conviction test quite robustly. There is this idea that sometimes when they're prosecuting, there used to be a saying, just, throw them against the wall, see who sticks. In other words, we don't think this evidence is particularly good, but we'll stick it in there and we'll leave it to a jury. I mean, the good thing about prosecuting, as we always say, the prosecution achieves no victories but suffers no defeats. In other words, prosecutors are just ministers of state, and they're laying out a case. They don't have an interest in whether there's a guilty or innocent, guilty or not guilty verdict. They're just supposed to lay the case out. So in this particular case, though, they've taken the view and said, we don't think even this evidence taken at its highest, a properly directed jury could find, as a matter of fact, that China was an enemy. And this is what now everybody's going, well, hang on a second. These statements do seem... So I'll leave it to you, because you are in the best position to decide this, I think, because, you're the sort of people who would end up on a jury. So have a read through, and do you think that the evidence, counts as an enemy? I mean, I suppose it's because a lot of it's about economic stuff, but, economic harm is something that the intelligence services and the security services actually deal with. I'll do one of my anecdotes, actually. One of my friends works at one of the agencies. And this was in the period sort of between the fall of the Berlin Wall, but before 9/11. So they were sort of twiddling their thumbs a little bit. But they had a serious crime remit, which they decided to activate just to justify themselves. And I got a phone call. My friend is a lawyer. I said, here's an interesting thing. If we were to do this and enter a premises and blah, blah, blah and do this, would the material we find, would that be admissible in criminal proceedings? And I was like, that's an interesting question. Yeah, think about that. When do you need to know this by? And it's like, any time in the next 90 seconds. So that was it. In the end, the advice was, have you got any just regular police officers around? You just grab a constable and drag him in there with you and get him to do the arrests. And, we're all sort of joking about, I mean, if you speak to any old CID guy, or any old police officers, what's the powers of entry into premises? And it's the old I can smell gas. that was always the old one for entering. But yeah, I mean, economic harm. That is economic warfare has been around forever. I mean, Sun Tzu writes about it, so there's nothing new there. So I just thought as always, you might find that vaguely interesting, vaguely informative, and like I say, I'd say vaguely accurate, but I'm actually going to link to the statements so you can form your own views on there. And I think it's interesting. I don't think this one's going to go away, because apart from anything else, there's sort of, implications for future trials. I mean, obviously, without, I don't get into the politics too much, but the accusation is that we don't want to offend China. And you know, because they're one of our biggest trading partners now, and potential biggest trading partners. You know, and also, the world is changing. You know, we don't have to have, we don't have to have enemies. We can all be friends and all that sort of thing. So, the argument is that they scuppered the trial just to protect this for the benefit of international relations. I'll leave that as an exercise for the viewer. But yeah, there you go. So I don't think you have to go back and look at my previous video now, because I pretty much repeated what was in it, although do feel free, because it's always nice to get the clicks and stuff. Because as I always say, I'm not bothered if you like or subscribe or anything. I'm just grateful if you watch these things and stuff. But every time I do say that, because you're all contrarians, loads of people subscribe. So let's just do this as a little experiment.